You may be aware that the Free Market Foundation has launched an action in the High Court. What is this case all about? When you grow up in apartheid South Africa, you face many challenges. You learn very quickly what can and cannot be done. For example, you learn very quickly that there's no security in having a job. Even today, many South Africans struggle to find employment, struggle to feed their families, struggle to avoid being one of the nearly 8 million unemployed. Our country today has one of the highest unemployment rates in the developed world. Long-term unemployment has a devastating effect on the lives of people. They lose skills, status, self-belief, and employability. If they're young, they lose on-the-job training. They give up hope and become mired in poverty. Our country simply cannot allow such soul-destroying circumstances to continue. Our mass unemployment is eating like a cancer at the vital organs of our democracy. This has to change. A very few, myself among them, managed to find a way, despite it all, to strive and prosper. I managed to secure the financial freedom I have now, a freedom to see what I can do to help address the problem. My name is Herman Mashaba, and I'm the chairman of the Free Market Foundation. It is an organization that for many years has been seriously worried by the high level of unemployment and poverty in our country. As a nation, since we won our freedom from the evil system of apartheid, our government has worked tirelessly to redress the situation and ensure secure employment. They may even have succeeded too well. The high level of security and income now provided by the labor laws has unintended consequences of preventing the unemployed from getting jobs and skills. How does that work? Labor laws that are suitable in large firms can have catastrophic consequences in rural areas and for small firms and unskilled employees. One size does not fit all. It never has. As an example, in bargaining councils, once participating parties have agreed on terms and conditions of employment, including wage scales, the Minister of Labour has no choice but to extend the agreements and make them enforceable on everyone else in the same industry. Now, this has no regard for how different they might be in regard to where they are in the country or their personal differences. But even though they have not participated in the negotiations or agreed to the terms, they have to comply. In other words, the big guys make the rules for the little guys, with absolutely no consultation or participation. That is scarcely democratic. What happens then is that bargaining councils representing elites have their agreements extended to small firms and unskilled workers. In so doing, they know very well that many of the small firms and disadvantaged workers will not be able to sustain the wages and provide the benefits stipulated in the agreements. But they go ahead and impose the agreements anyway. Those who are responsible show a callous disregard for human suffering. Are we challenging the rights of bargaining councils to make agreements? Not at all. Are we challenging the rights of labor unions to represent their members to the best of their abilities? Not at all. Are we being unpatriotic in taking government to the highest court to stop this extension of agreements to everyone else in the industry, wherever they may be in the country? Not at all. That is what the courts are for. Our challenge says quite simply that if you didn't have a say in the negotiations or agree to the terms, then you should not be bound by them. We feel at least as strongly as anyone about the right to collective bargaining. Where we differ is that while we defend their rights, we also defend the rights of their competitors, especially the poor and destitute fellow South Africans. The Free Market Foundation will not stand by and watch more people being denied work in this way. We believe that stopping this practice will increase the demand for labor in South Africa and bring about a dramatic decline in unemployment. All we ask is that parties to agreements should not be allowed to tell the minister what to do. That the minister should be free to extend bargaining council agreements, but must first consider the implications for non-parties. We cannot see how any reasonable person could disagree. So what is the point? Well, it comes down to a matter of choice. More importantly, who makes that choice? If I think that discrimination is unfair, I have the freedom to say no. I can also say no if I feel I'm being unfairly exploited. Government or anyone else to make the decision for me takes away my hard-fought freedom, my freedom to decide for myself. And in so many ways, this is what is happening now. It is patronizing and demeaning. So, this court challenge is directed solely against the compulsory extension of the bargaining council agreements to non-participating third parties. Many of them are small manufacturers, and many of them are based in high unemployment rural areas, exactly where the need for employment is greatest. That is where the damage is done, and that is what our challenge is about. Let's retain the right of our small businesses and our workers to make their own decisions, to choose for themselves how they'll put their talents and labor to work. It will restore the dignity and self-worth of millions who are denied employment by well-meaning but nonetheless toxic practice.